9 a.m. docket and one case on our 10 a.m. docket. The division is going to be reconstituted between the 9 a.m. and the 10 a.m. docket because Judge Casebolt is going to be substituting, Judge Nieto is going to substitute in for Judge Casebolt. So our counsel here for People v. Koper at table, is that correct? And is counsel here for People v. Mohamed? All right, very good. I know that you're both experienced appellate advocates. Have you had the opportunity to review our procedures, and are there any questions? Okay. I would just ask that everybody make sure that your cell phones or other electronic devices are turned off so that they do not interrupt the presentation of counsel or interfere with our recording system. Also, I would remind counsel that these arguments are being live streamed and archived on the internet. So please make sure that when referring to sensitive information that you don't necessarily want out there, that you do so with that in mind. With that said, we will go ahead and call our first case, People v. Koper, 15CA1912.
Good morning, and may it please the court. My name is Jessica Pitts, attorney registration number 48932, and I represent Mr. Brian Koper, who's present here today. No one contests that Mr. Koper was justified in acting in self-defense when he pulled out his concealed carry handgun to protect himself against an ongoing assault and to keep his assailant at bay. The issue in this case is only whether the jury should have been instructed that his justifiable use of self-defense should transfer to two innocent bystanders. The doctrine of transferred intent is a well-established principle of law. The usual case where we see this is, for example, in first-degree murder. If after deliberation you intend to kill somebody and you shoot that person, but the bullet misses and hits an innocent bystander, we would say that your intent as to the person you meant to kill transfers to the other person that you did kill so that you can be charged with first-degree murder in that case. Colorado courts have recognized that this transfer justification applies to self-defense cases, so that if you're defending yourself against a person, but you unintentionally hit an innocent bystander, your justified use of self-defense, that justification should transfer to the innocent person as well.
Ms. Pitts, are you referring to that really old Colorado case in 1913 that dealt with the self-defense issue?
Yes, Your Honor. There are two fairly old cases and a more recent Court of Appeals case that's mentioned this concept as well. So the two older cases are Henwood and Agnes is the 1939 case. The Court of Appeals in Castillo again referenced this concept as well.
Castillo really didn't discuss transferred intent all that much, did it?
It didn't. But it did mention the concept in a more recent case than 1939. But again, I think the doctrine of transferred intent, when we're talking about, say, a first-degree murder case, that's a much more common situation. So Colorado courts have recognized, though, that same concept should apply in self-defense.
Are both the victims here identically situated? I mean, with respect to, I'm going to refer to them as the male and female because I think just to keep everybody straight. With respect to the woman, her testimony was that she was essentially kind of behind where the target was, Abram, and therefore, to the extent the gun was pointed at her, it was sort of incidental to the defendant tracking the person that he was trying to keep at bay. But with respect to the man, his testimony was that he approached a 45-degree angle, and the defendant took his aim off of the person he was trying to keep at bay, and pointed the gun directly at him, and also then told him the gun's loaded, and everybody backed off. And in his testimony, he doesn't admit that he pointed the gun at him. Instead, he basically is contesting that, no, I kept the gun trained on Abram and never did what I'm being accused of doing as far as menacing goes. So it's not, I did it, but the act is taking and aiming at the victim. So why would self-defense apply with respect to the male victim?
So I agree that the witnesses testified to something different than Mr. Koper testified to. So when we're talking about whether you're entitled to a self-defense instruction, all you need is some credible evidence, or sometimes it's just a scintilla of evidence. And his credible testimony that was corroborated by other evidence certainly meets that standard.
What's his testimony in that regard with respect to the male victim?
His testimony was that the male victim approached him, put his hands on the weapon, and sort of injected himself into the line of fire.
I thought it was that but he didn't ever point the gun at him at all. So really his testimony was, I never menaced him, as opposed to, I incidentally menaced him in self-defense.
Right. His theory of defense was that to the extent anyone menaced, I didn't knowingly do so. But I don't think that's inconsistent with saying, but if someone was menaced, I did so in self-defense. So that's a pretty...
Are you allowed to ride both of those horses?
Absolutely. You're absolutely allowed to have different theories of defense, where you can say, it wasn't me, I wasn't there, but if I was there, it was self-defense.
Might not be successful, though.
Well, it's up to the jury to decide what they believe. So in this case, it was a jury question whether they believed the male and female witnesses or my client.
But there was no evidence, was there, that defendant thought the male victim was somehow associated with the assailant?
No, Your Honor. No.
Okay. In fact, I think counsel at trial said, we don't contend there was any self-defense as to either of the victims, because we weren't trying to menace them. They weren't our intended victim. The assailant was.
That's correct. That's correct, Your Honor. There was no evidence that either of those parties were menacing him in any way. They were truly innocent bystanders. He was protecting himself against his assailant, and in doing so, he was invoking his right to self-defense in a crowd.
And you say you can kind of run both of them at the same time, but you're not entitled to an affirmative defense that contradicts the defendant's testimony. So if the defendant is testifying, I never pointed the gun at the male assailant, you're not then entitled to but if I did, it was in self-defense. Are you?
I don't think that's the case here. I don't think it was truly inconsistent. He's saying I was defending myself against someone, and in that justified use, there were other people around. I was invoking my right to self-defense in a crowd. Other people may have been menaced, but my intent with regard to the assailant, that's what should transfer to those innocent bystanders. The problem with the contrary holding is that if it's true that you're not entitled to self-defense as to innocent bystanders anytime you're in this case, pulling out a weapon to defend yourself, that you could be charged with a felony just because there's other people around, that it cuts down on your right to self-defense by a substantial degree. And
what about because this almost, the menacing almost occurred when the bystanders or one of the bystanders was attempting to disarm the defendant.
Yeah.
They weren't Confederates of the assailant, but do you have a right to fend off innocent bystanders from disarming you? Is that part of the duty not to retreat? I mean, in other words, even though they're not Confederates, do you have the ability to sort of stand your ground in continuing to keep the weapon trained on somebody and potentially menace a non-Confederate individual who's attempting to disarm you?
I think that would go to the reasonable use of force, and that could be a question for the jury. Was that use of force, if he needed to keep others from disarming so that he could continue to protect himself from his assailant, that the jury could decide whether that was reasonable or not?
So in a situation where you've been involving a crowd, and given the prosecution the district attorney has in charging crimes against people for various victims, are you saying that in this situation, assuming the jury believed that he was waving the gun around, which there was some testimony about, that the district attorney could not charge the defendant with any kind of crime for any of these innocent bystanders?
I'm not talking about charging decisions. The crime has been charged. The issue in this case is whether the jury should be instructed that self-defense does apply in that situation, and then the jury should decide whether my client reasonably used self-defense in that situation.
Ms. Pitts, I think that you're probably figuring out is that a concern here is the scope of the rule that you propose. Obviously, when you talk about the woman in this case, she was in the line of fire and so could reasonably be anticipated to be a person whom transferred intent theory would work on. But if you start talking about one bad actor and a crowd of people, and suddenly waving the gun around, you've suddenly menaced 10 people, 15 people who have nothing to do with the confrontation. Are you suggesting to us that those people cannot be victims of this crime, or in the prosecution for those people, the affirmative defense would be appropriate? For example, let us say that I have been the bad actor and you are pointing your gun at me. Well, what if you wave it and point it at Judge Casebolt? Are you saying that you would have self-defense considering the distance between us? You'd have a self-defense claim against him in the charge involving him?
So the limiting principle here is reasonableness. So, and that's a jury question. If the jury thinks that if I waved it around that was reasonable, they could decide that, or they could determine that I wasn't reasonable in my use of force and then was not entitled to self-defense. So there is a limiting principle here, and that's reasonableness.
So you're saying a trial court could say, no, we're not going to say that it would be reasonable to give self-defense for pointing the gun at Judge Casebolt in my hypothetical.
I think that's a question for the jury, not a question of law, as to whether that action was reasonable.
Thank you.
Maybe much in the same way that transferred intent for self-defense for a murder, where you were fending off assailant A and fired and hit B. You can argue transferred intent, but it's up to the jury as to whether or not you acted reasonable in firing and or whether the risk was an undue risk firing at your assailant in a crowd, knowing that other people could be hit. But at the end of the day, it's a jury question.
Yes, that's my argument.
Okay.
And in this case, the jury should have been instructed on self-defense so that they could make that determination. Was his use of force reasonable as to Abram? And if they were instructed that if that's true, if they found that they should acquit him as to the menacing as to the two innocent bystanders.
So who decides the issue of transferred intent? The jury, right? It's not a question of
As
law
to
for the court, is it? If the court gives the instruction and says, you can apply self-defense here, jury, if you wish. But it's up to the jury to decide, was it transferred intent or not?
I think, so if there's a scintilla of evidence supporting self-defense, the court should give the instruction. So that's the question for the court. And then the question for the jury is, was that use of self-defense as to the assailant reasonable? And in that act of self-defense, were innocent bystanders menaced, or in a different case could be shot, in this case menaced?
Is there a special instruction that would need to go along with the normal pattern self-defense instruction for the issue of transferred intent?
I think it would be helpful to the jury to have that. I do think
Was that tendered here?
There was not a specific transferred intent instruction. I do think that the instructions tendered in this case by defense counsel would have been sufficient. I think it could be helpful to the jury, but not strictly necessary. I think the concepts, if they were instructed that self-defense is a defense to the charged crimes, that would be enough to inform the jury as to what to do.
But it could be advisable to also then craft what transferred intent looks like, right?
Correct, and depending on how the evidence comes out at trial, that's something that the trial court could work with defense counsel. If there's no further questions at this time, I'd like to reserve the remainder of my time for rebuttal.
Thank you, Ms. Pitts. Ms. Price.
May it please the court, my name is Jillian Price, registration number 40815, and I represent the people. I'd like to start by responding to the transferred intent example that Ms. Pitts has raised here. Now, in a transferred intent situation, obviously that is usually seen in a quote-unquote bad aim case where the defendant intends to shoot or otherwise harm victim A and instead misses and harms victim B. Now, there is a very good reason why that theory of defense, or rather theory of imposing criminal liability, is normally seen in murder or assault cases. Looking at the statutory language of the first-degree murder statute, for example, and second-degree assault, both of those statutes incorporate the concept of transferred intent. Murder 1 is defined as intending after deliberation, quote, to cause the death of a person and causing the death of that person or of another person. So we have statutorily incorporated the idea of transferred intent into murder one. Similarly, in second-degree assault, one commits that crime if they intend to cause bodily injury to another person and cause such injury to any person by means of a deadly weapon. So again, we have the incorporation of that theory of imposing criminal liability. Menacing, by contrast, does not incorporate that language statutorily. Menacing is committed if a person, by any threat or physical action, knowingly places or attempts to place another person in fear of imminent serious bodily injury.
But now you're saying anytime you pull a deadly weapon in a crowded location, given that this inchoate element of menacing, that it's not just placing them in fear, but attempting to place them in fear, in other words, taking a substantial step towards doing so, now you've got menacing for the entire room full of people except for the assailant.
Well, so here's how I would respond to that. So when you have, so taking Judge Bernard's example, let's say, for example, we have 3 people coming at the defendant who intend him harm, okay? Let's say that there is a fourth person in the mix who is an innocent bystander, maybe wrong place, wrong time. If that defendant pulls out that weapon to defend against those 3 people, and also menaces the fourth person, in that situation, then I could see a reasonable transferred self-defense justification. But let's tweak that hypothetical a bit and make it look like this case. Let's say we have one assailant. Let's say that assailant punched the defendant twice in the face, right? So that defendant, assuming that it's reasonable to bring a gun to a fist fight, and the people neither concede nor deny that, but...
Jury question on that.
Sure, exactly, jury question. But assuming that that's reasonable, okay, then that defendant has that one trajectory, okay? The defendant can defend himself against the one assailant that's coming after him, intending him harm. That does not mean that the defendant gets to, as the female victim testified, flail his gun and wave it at everyone in the room.
But the testimony also was that Abram was moving back and forth, that he didn't just retreat and immediately go to the ground where the defendant could keep his weapon trained on him, but he was moving around and continuing to threaten the defendant. So in this case, it was one of those circumstances where, if you believe the defendant's testimony, there was the flailing of the weapon around, though it may have appeared to be that's also consistent with keeping the weapon trained on the person potentially committing the assault. So, I mean, why isn't this then a jury question as to whether or not that conduct was transferred intent, where he was simply trying to defend himself, as opposed to, willy-nilly putting the entire bar in jeopardy?
Well, whether or not he acted, as you said, willy-nilly and put the entire bar in danger.
Legal term of art.
Sure, indeed, a very good term of art. That discrete issue certainly would be a factual issue for the finder of fact to determine, certainly. But when we are talking about assigning an affirmative defense to a case, that is the legal question. And the conduct in this case simply did not justify that affirmative defense.
But if it's any credible evidence, which is the standard we've got to apply to decide if a self-defense instruction is appropriate, isn't there some credible evidence from the defendant himself that he didn't flail his weapon around?
Well, he said that, sure, he said that he kept his weapon trained on Abram. But the overwhelming bulk of the remainder of the evidence, I believe 8 witnesses that testified for the prosecution who were in the bar and also saw what happened, shows that he did indeed flail his gun. The female victim in this case testified. She said he was going like this. The court then clarified for the record that meant waving it from left to right. Even if the assailant was moving back and forth, as Mr. Koper said he was, that still did not give him the right to flail that gun. If I hear somebody...
That's an issue of fact, is it not? I mean, that's for the jury to decide. Do we believe him, or do we believe the other 8 witnesses?
Right, that is a factual...
But why doesn't he get a self-defense instruction on that issue if they believe his testimony and nobody else's?
So going back to your initial question as to the scintilla of evidence or some credible evidence, and referring back to what Ms. Pitts described, his primary theory of defense, as articulated at the jury instruction conference and indeed throughout trial, was that he did not knowingly menace either the male or the female victim. He said that he did not even realize that the female victim was there, and he said that the male victim inserted himself into harm's way. Now, that is indeed quite inconsistent with with the affirmative defense of self-defense.
Well, okay, except he didn't admit that he actually menaced. I agree with you. But he did say, I pointed the gun at Abram. And isn't that admission of conduct that if the jury thought it was with the appropriate intent, et cetera, is menacing?
As to, well, in self-defense as to Abram, sure.
And as to
But
the
not-
person right to the right of him where, you know, he might shoot and miss.
But as to the male and female victims in this case, again, he has the right, presumably, again, assuming his conduct was reasonable, to defend himself against his assailant. And the jury does need to determine reasonableness. That is a factual distinction. But looking at whether or not there was sufficient or some credible evidence to support the affirmative defense of self-defense, that simply wasn't present given his theory of defense here. And I would argue that it's more akin to an element negating traverse, which obviously applies only in cases of criminal negligence, recklessness, et cetera. This was a knowingly crime, so I certainly recognize that. But when the primary theory of defense is that, hey, I lacked the requisite mental state to commit these crimes, that is wholly inconsistent with the affirmative defense of self-defense.
That was his jury instruction after he was denied self-defense.
And his jury instruction said, you know, I had the right to, let's see, I have it flagged here. He was assaulted by Abram. He drew his firearm, quote, solely for the purposes of preventing further assault and holding that assailant at bay. His actions were entirely focused on preventing further assault upon him, and to the extent that the male or female victims may have been in fear of imminent serious bodily injury, he did not knowingly cause that fear. Now, at the jury instruction conference, Mr. Koper said that he wanted the jury to be informed in some way, shape, or fashion in these instructions that he is entitled to defend himself against an assault. He prefaced that statement, and I'm looking at the August 12th transcript, page 244. He prefaced that statement by saying, well, Your Honor, certainly he wasn't defending himself against the male or the female victim. And he wanted the jury, again, quote, in some way, shape, or fashion, to know that he was entitled to his behavior as to Abram. And that is precisely how the jury was instructed. So
But it wasn't instructed that the prosecution had the burden of proof to disprove it beyond a reasonable doubt, which is a far cry from just describing the theory of defense in a theory of defense instruction as opposed to placing the burden on the people to disprove it beyond a reasonable doubt, right?
Well, and I think because his defense is that he lacked the requisite mental state and he in no way, shape, or form admitted to conduct as to these victims, and because he was not entitled to flail that gun around, this was not an affirmative defense situation.
Disputing the requisite mental state and asserting self-defense are not inconsistent if the defendant admits the conduct, right?
Well, the only conduct that he's admitted is defending himself against Abram.
No, it's pulling a gun.
Yes.
Pulling a gun in a crowded room. That in and of itself can be menacing. Now the question becomes, did you do it with the requisite intent of knowingly wanting to place these individuals in harm's way, right? And you can claim that I didn't knowingly do that, and I also acted in self-defense. I mean, those are not inconsistent to admit both the act and dispute the having the requisite mental state, right?
I think in this case, those two things are inconsistent. He admits he pulled the gun. There's no dispute about that. He admits he was defending himself against Abram. Again, no dispute about that. He specifically says, I am not defending against the male or the female victim. I'm not defending against them. He says that he has, I'm paraphrasing here, but he said that he was warning Mr. Brown, hey, this gun is loaded, go call the cops. He did not perceive any threat from Mr. Brown. He says, or the male victim, I apologize. He says he did not even realize that the female victim was there. So again, no threat from her. Indeed, at the beginning of the evening, he walked in, she gave him a hug, he bought her a drink. There's no threats from either of these two victims.
Well, that's what transfer intent is all about, right?
And in this case, though, again, going back to the trajectory example, he, again, assuming that bringing a gun to a fist fight is reasonable, which is a jury finding, he could defend himself against Abram. He is not entitled to flail his gun around. There is no evidence that he felt any kind of threat from either of these victims, and yet, as the male victim testified, he went from pointing his gun at the assailant to pointing the gun at his face, which placed him in fear for his life.
Well, that's his testimony. That is not consistent with what the defendant testified to, right?
The defendant certainly had his own version of the events, yes.
And it's up to the jury to decide which version they believe, right?
That is a fact question, sure, but again, given the defendant's stated theory of defense, his repeated theory that he did not do this knowingly, he had no intent to menace anybody, he was simply acting in defense as to Abram. There was no need for the affirmative defense in this case, and the instruction that the jury did receive fully explained his theory, fully explained his defense, and there was no need for the elemental affirmative defense that he requested.
Ms. Price, pardon me for interrupting. I would like to change horses here while we still have a little bit of time.
Sure.
I want to go to the Liggett issue, if I
Okay.
may. It strikes me that Liggett was decided in 2006, so we've had 12 years of it, and yet we have a prosecutor in this case arguably committing over 40 instances of Liggett error. I'd like you to address that, please, and tell me why I shouldn't be concerned about that.
This was a case where not everybody could be exactly right. We have, again, I believe 8 witnesses for the prosecution, all of whom are at a bar, all of whom are drinking or have at least had one drink, all of whom are at different perspectives. So we do have various accounts of what happened. We also have Mr. Koper's testimony. He said that the male victim's version of events was completely wrong, and he said that the, quote, the testimony of everybody was inaccurate. So when the prosecution is going through and questioning him and says, okay, well, the male victim said this, is that right or wrong? Is that accurate or inaccurate? I agree that comes close to the Liggett line, but at the same time, in the context of this case, where not everybody can be right, the point was to establish an accurate timeline of what happened. Additionally,
Again, pardon me for interrupting, I'm sorry, and I'll shut up after this question and let you answer, I promise. But my concern here is that there was more than a step of simply, is it accurate? There was other language used suggesting that somebody was lying. And as you and I both know, two people can perceive the same event, provide an explanation of that event, and not be lying in the classical sense. Someone might be mistaken. The different perspectives might provide a difference in viewpoint so that they're both accurate in a way. So my concern here is with the vocabulary. Could you address that, please?
it's more important, in my view, to look at the context in which a word is used instead of the exact word. This court should not be in a position to excise a word or a class of words from an attorney's vocabulary. We should instead look at the context in which it is used. And that, again, in this case, is to establish an accurate timeline. And I will add that this was on plain error review, and the lack of objection here may very well have been a sound strategy decision such that Mr. Koper could explain his version of events and let the jury hear his side of the story. And indeed, his testimony likely, may I finish?
Oh, please.
And his testimony likely bolstered his side of this case. Given all of those things and looking at the context in which these challenged words were uttered, there was no error and certainly not plain error.
Thank you.
Thank you very much,
Thank you.
Ms. Price. Ms. Pitts, you have just a little bit under 3 minutes remaining.
The Attorney General argues the plain language of the menacing statute, and in the briefs argues the plain language of the self-defense statute to support their argument that no instruction was needed here. This court has a duty to interpret statutes to avoid absurd results. And to have a result where if you defend yourself with a deadly weapon and there are other people around that you could potentially be charged with multiple felonies, that would be an absurd result. Your right to self-defense shouldn't rise and fall with whether there are people around watching.
Well, you can potentially be charged, because this isn't a charging issue. It's just a question of whether or not the prosecution bears an additional burden of disproving self-defense beyond a reasonable doubt, right?
Exactly. That, just as in any case, you should be entitled to self-defense instruction if there's credible evidence of self-defense. And that's the issue in this case. And again, as you mentioned, this is the state's burden to disprove beyond a reasonable doubt if there's credible evidence supporting self-defense. It's not a traverse, and that's why the instruction actually given in this case, the theory of defense instruction, didn't cure the error here, because the jury was never instructed that the state had to disprove it beyond a reasonable doubt.
And if we agree with you on that, does that just go to the menacing charges, the other convictions stand? Is there any spillover prejudice from a lack of a self-defense? Because it's not a defense to the other charges he faced of drunk with a gun, or possessing a gun while intoxicated.
Yes, Your Honor, I think you're correct, that this instruction issue does only go to the menacing charges.
What if we thought that he was only entitled to self-defense as to one of the victims, but not to both? Do we just remand on that one charge? If we conclude that entitled as to the woman, but not as to the man, for example, would that just necessitate reversal on one of the two?
I think this court's decision is whether there was credible evidence of self-defense and answering the legal question of whether that justification transfers to two innocent victims. And then it's up to the jury to decide whether that self-defense should apply to either.
You're saying I would be slicing the bologna too thin if I was to maybe say he was entitled to it as to one but not both?
Again, I think that's a jury question. I think that's a factual question. I think the legal question for this court is just whether there was enough evidence of self-defense such that the jury should have been instructed on self-defense as to the two victims. And then the jury can decide whether he was entitled to it based on the different testimony and how that testimony would come out at the retrial. If there are no further questions, I'd ask this court to remand for a new trial.
Very good. Thank you, Ms. Bitson. Thank you, counsel, for your excellent arguments as well as the briefing in this case. The case will stand as submitted and a written opinion will issue in due course. Our next case on the docket is People v. Mohamed. So if we could have counsel for that case, come on up. So we will call the second case on the 9 a.m. docket, which is 16CA1467, People v. Mohamed. Do counsel have any questions about our procedures? No, sir. All right. And I would just reiterate the reminder that I gave counsel for the last argument about this being live streamed as well as archived on the website. So please be sensitive to that when making references to, particularly to named individuals in the case, to either go by initials or more generic terms. With that said, we will go ahead and begin with the defendant.
Good morning. My name is Joseph Huff. My registration number is 34384. I'm from the Public Defender's Office, and I represent Mr. Mohamed. I think it's important that we all are on the same page here with regard to what the defendant's entire theory of defense was, and that was that both of his children had made this up, had made the allegation of abuse up because they disliked living with their father. He was not permissive at all. He was a very strict disciplinarian. They wanted to live with their uncle, or the man they referred to as their uncle, Mr. Abukar. Our theory was that...
Let's just refer to him as the uncle. This is what I'm talking about with respect to trying not to name names.
Okay.
I appreciate that.
So our theory was they wanted to live with their uncle because their father was not very permissive. He was a very strict disciplinarian. So they concocted this scheme to allege that their father had beaten the son. And our proffered testimony was from
The friend.
HD.
Or the friend.
Sure.
Friend of the defendant. How about, we'll
Right.
call him a friend.
His proffered testimony went precisely to that theory of defense, went precisely to the motives as for why the children would have concocted this scheme. And again, I'm going to repeat what it was. He observed the uncle spending time with the children at a park before this allegation occurred.
Do we know that? We know that it was spending time at the park before the children were removed from father's care, but what do we know about where it fit on the timeline? Because remember, there was a stabbing incident, and then there was the haircut incident.
Right.
And I just was unclear about the timing of the conversation that the friend overheard between the uncle and the son.
I don't think the offer of proof is that explicit. I think you can read between the lines and reasonably ascertain that it occurred after the stabbing incident, which occurred presumably a year or two earlier, but before the alleged bludgeoning.
Was there that much separation in time? I'm sorry, I didn't realize that there was that much separation in time between the stabbing
I
incident and the
thought there was
bludgeoning.
at least a year, perhaps as little as 6 months, but I know there was some significant period of time in between those two assaults. And again, they acquitted him of the stabbing assault. So our argument was they concocted the bludgeoning, the alleged bludgeoning, in order to live with their uncle. This man observed, this neighbor of theirs, someone who's close to their family, observed the children with the uncle by themselves at the park. He heard the uncle, and this is what's critical, say that the defendant did not care for him and, quote, he would be a better caregiver. And then, to top it all off, he heard this man say, I'm instructing you to go against your father.
I didn't hear, I'm instructing you to go against your father, just that he was encouraging them to go against their father.
Instructing, encouraging, I think you can say that he told them to go against their father. Now, whether he ordered them, whether he suggested, the thing was he told them, look, I'm a better caregiver, he doesn't love you, basically come live with me, go against your father.
That's not tantamount to saying make up a story. It is saying, you know, it could be just as easily interpreted as have the courage to stand up to your father for what he's doing to you. Basically, be truthful and come forward, as opposed to make up a story. From the offer of proof, wouldn't the jury be speculating as to what he was encouraging the children to do? Because your theory requires that the jury conclude that he was encouraging them to fabricate, not simply come forward.
Well, I think you have it exactly right, Your Honor. It's a jury question. It could be regarded either way. The way we presented it as, we want to argue that to the jury that based upon this, he was telling them, go against your father. Make something up. Make a story. Come live with me. I'll be more permissive. You'll enjoy living with me. He doesn't care for you. Presumably, I do. I agree. Your interpretation is valid. A jury could interpret that as valid. But our point was we need to present this evidence to the jury so we can put out our perspective, our belief in what this conversation with the children meant.
But isn't it speculation to draw the inference that you're asking the jury to draw from the testimony as contained in the offer of proof?
Well, I think it would be equally as speculative to draw the inference that you proposed. The point is, juries draw inferences. We put forth evidence. One juror might have one perspective on what it means. One juror might have another perspective on what it means. I think it's entirely reasonable and logical to take from this conversation that preceded the alleged assault that this man was trying to take these children away, encouraging them to live with him. And that was our entire theory of defense, that these children had a motive to fabricate this. And this motive arised from this, their uncles telling them that come live with me, it'll be better. And I think it's valid to interpret that way, and I think it's equally valid to interpret it some other way. Come forward if there's abuse, but there was no offer of proof that in the context of that conversation, they were discussing any abuse. Now, if the offer of proof had been the children came to their uncle and said, he's been beating us, we don't like him, and then he says, we'll go against him, that could be validly interpreted as call the cops, go against him, report him, but there was none of that. So it is speculative, but a lot of things are speculative, and the point is that's why we have juries, to sort out that sort of speculation and to determine what they believed this conversation meant.
Pardon me, Mr.
Yes, sir.
But I suggest to you that's also why we have judges to determine whether something is relevant or whether it requires too much speculation. I mean, that's part of a judge's job. If you're going to have something that requires so much speculation that you could have two, and you've identified actually three different interpretations, and I would suggest to you that there are probably many more of what go against your father might mean. At that point, isn't it the judge's job to step in and say, look, this is so vague, this is so ambiguous, that I'm not going to ask the jury to try to speculate as to what it means, because it is possible that it could mean any of 5, 10, 20 things.
That's fair in some instances. In this instance, the court never made that finding. The court's finding as to why he was excluding this evidence was very brief. It's not relevant in a criminal case in terms of specific incidents and this allegation.
Do you think he was referring to CRE 404B when he talked about this incident?
I wouldn't want to speculate as to what he was talking about. I think the judge in this case was honestly trying to do the right thing, but missed the mark in saying this wasn't relevant. I don't know what he was thinking. Again, I wouldn't want to speculate, but in my opinion, in our interpretation, particularly that our entire theory of defense rested upon this, it was entirely relevant, and maybe the jury could have come to a different conclusion. But the point is, this was relevant evidence. It was highly probative, particularly to our theory of defense. We weren't allowed another avenue to get into this. When the court says it's irrelevant, we can't bring it up in either way.
This argument was, I'm sorry for interrupting. This argument of foreclosing any opportunity to make your theory of defense was not presented to the trial court, either directly as saying this is a due process problem, this is a constitutional issue, or even asserting it the way that you're asserting it now, that it's a complete foreclosure of the opportunity to present the evidence. Because I saw no mention of a constitutional objection before the trial court.
Well,
did I miss something? Sorry.
No, sir. We never once mentioned the Constitution. But the same exact scenario happened in the Golob and Melendez cases. I don't have the cites on me. They're in the brief. In both those cases, our Supreme Court said the attorney below did not need to cite certain specific provisions of the Constitution. When you say I have a witness that goes to my defense and I want to call him, that implicates the Constitution, whether you say this particular provision or not. It implicates the Constitution. It puts the court on notice that you're trying to exercise your right to present a complete defense, that you're trying to exercise your right to a fair trial and due process and compulsory process. It doesn't need to be talismanic language, as Melendez says. And in both of those cases, the court found that the constitutional objection was preserved when we moved to call a particular witness in support of our theory of defense, and that was denied by the court.
Mr. Huff, with regard to that contention, is there any evidence that the children were cross-examined about this incident, and could they have been?
I'm saying when the judge says, when you bring up something and he says it's irrelevant, it's irrelevant. It's off the table.
Forgive me, I haven't read the record, so I don't know when this happened in the sequence of the
This
trial.
happened
This is
after
the defense's case, right?
This happened after the prosecution's case in chief. They closed their case, and we wish to call this particular individual to testify.
But the children did testify, did they
The
not?
children did testify. We did not cross-examine them, and I would put forth that had we cross-examined them, they would have denied it, as they Our whole argument is they fabricated this allegation, and then we wouldn't have had any way to rebut that because the court said, this is irrelevant, you can't bring this up. So it wasn't that important that we cross-examine the kids about it and they deny it. What's important is whether we cross-examine the kids or not is immaterial because they'll probably deny it. We want to put on an independent witness to say, I saw this, I heard this, and goes directly to our theory of defense. We had no other way of bringing that out other than this witness.
Actually, you did, which was to ask the son that, because this was a conversation between the uncle and the son that was overheard by the friend. And the son testified at trial and was never asked this question. So that was an opportunity to present it. And you would have had then a different argument or an additional arrow in your quiver to justify calling the friend to the stand, both to present this evidence as well as to rebut and to impeach the son's testimony, right? And you didn't take advantage of that opportunity.
It may very well have been a strategic choice not to do that at that time. Again, we don't know if this evidence is coming in or not. We haven't argued this in limine. We don't know if this man is going to be able to testify. We cross-examine these children or the son on this, and he flat out denies it. We have then no way to rebut it. So we might have said, look, we're not going to take the risk that we cross-examine the son on this, and he says flat out, no, I don't even know who this man is. And then we're not allowed to ever bring this in front of the jury to impeach that.
What about us asking to recall, if you're not going to be allowed to call the friend, what about requesting to recall the son to do this line of inquiry?
We could have, but the court actually ruled that it was irrelevant. Presumably, if the court says it's irrelevant for every reason, and we couldn't bring it in.
Pardon me for interrupting, Mr.
Yes, sir.
Huff. I just want to make sure that I understand your comment about we didn't cross-examine, because it appears to me you did cross-examine the two kids.
Not on this point.
But you didn't cross-examine them on this issue, is that correct?
That's correct.
All right, thank you. I just wanted to clear that up.
If there are no other questions, I'd like to save the rest of my time for rebuttal.
Thank you very much, Mr.
Thank
Huff.
you.
Is it Ms. Frias? Is that correct?
Yes.
All right.
Good morning. May it please the court, my name is Marixa Frias. My attorney registration number is 38746, and I'm here today on behalf of the people. I'd like to start with what's been discussed primarily in defendant's argument, is this theory of defense. On appeal, the defendant has claimed that the children made up these stories, these accounts of child abuse because they wanted to live with their uncle, because their father was a strict disciplinarian, he restricted their activities outside. But in preparing for this oral argument and looking at the record very closely, that is just not supported in the record. The record shows that what defense counsel was trying to do throughout the entire trial and the cross-examination of both children, all of the prosecution's witnesses, was simply to poke holes in the prosecution's case by emphasizing these inconsistent statements that the children had given. And they were minor inconsistencies. For example, in the cross-examination of the son, defense counsel elicited that he had difficulty remembering the time frame of when the event occurred. For example, in the 911 call, he said that the event happened at 3 p.m., but at trial, I believe, or in pretrial testimony, he'd said that his father had actually left the apartment at 3 p.m. Or inconsistencies regarding what the defendant used to cut the son's shirt. Was it with a knife? Was it with scissors? At trial, he couldn't remember whether it was a knife.
Right, so that goes to really the primary attack was they made this up. But the proof of them making this up was all these inconsistencies. That helps demonstrate why that this was fabricated, right? But the one thing that was missing from all of that, even when you line up all the inconsistencies, is the why, the motive for fabrication. And that is what the proffered evidence was going to go to primarily, was to help establish a motive. And in the closing argument, and maybe it was rebuttal close in particular, the prosecution actually seizes on this lack of motive to fabricate and says, you heard absolutely no evidence that would explain why the children would have made this up. Well, lo and behold, the prosecution did try to offer some evidence that would have helped fill in that, or at least give the jury something to seize on in that regard, but they were shut down from that. I mean, that's where this is particularly important evidence and goes to the theory of defense, as I understand the argument. You want to respond to that?
Yes, Your Honor, and respectfully, I disagree. I think that it's one thing to claim that these children have made a number of inconsistent statements regarding details of what happened, and it's another thing to say that they made these incidents of child abuse, that they fabricated those claims, and even going further to what defendant now argues is the theory of defense, that it was their uncle who influenced them to make up these incidents of child abuse. And the point is that at the time of the offer of proof on the fourth day of trial, the evidence that had been elicited up until that point, there was nothing regarding this theory of fabrication. There was no testimony from either child that they had been influenced by anyone. There was no testimony, for example, that they wanted to live with their uncle more than with their father. There was no testimony regarding this incident.
Right, because we'd only heard the people's case. I mean, this is what the defense case is about. I mean, what they established through cross-examination was inconsistencies. I mean, clearly the theory of defense has to be that if these allegations aren't true, they're being made up. So they attempt to establish some aspects of fabrication through cross-examination and eliciting inconsistencies as part of demonstrating that, but had to call an additional witness that wasn't called by the people to try and fill in the piece of the why, to explain why the children would have acted consistent with the theory of defense. And that's what the friend would have offered. Whether the jury ultimately believed him or not, I mean, that's up to the jury, but that's the importance of this particular witness's testimony and the conversation he claimed to have overheard.
Your Honor, in order for that witness to have been relevant to the evidence that had been presented at trial and to support their theory of defense, I think you would have to show that there had to be some offer of proof that this witness had observed these conversations taking place before the incidents occurred to support this theory that the children made this up. The theory of defense at trial wasn't that this didn't happen. I mean, perhaps to a logical extent, it's that it didn't happen in the way that the children said it did. But there's no denying that MA called 911, law enforcement responded. He had an open wound to the back of his head. He was treated at the hospital. The emergency room pediatric physician testified that MA's accounting of what occurred was consistent with his injuries.
That all goes to a harmlessness argument, and the question is whether or not it's a constitutional harmlessness or whether or not we're reviewing under plain error on the constitutional issue. But as far as relevance goes, I mean, certainly when this occurred, the thing that we do know about the offer of proof is that it occurred before the children were removed from their father's care. And I would assume, but it's not clear to me, that's why I asked Mr. Huff this, when the children were removed shortly after the 911 call, I would imagine, right?
It's my understanding that it was a few weeks later, I believe maybe 15 days later. They went first with an aunt for a week, another aunt for a few days, foster care for a few days, and ultimately with the uncle. And I know that they had their forensic interview on June 11th, 2014, and it was the uncle who drove them there, and I believe they were already living with the uncle at that time.
Right, but the conversation that was alleged to have occurred while they were in father's care.
Correct. So perhaps that could have gone towards the May 2014 incident, but you don't have anything for the April 2014 incident. And yes, there were some discrepancies regarding when the stabbing incident occurred. It's my understanding from the record that it was believed to have been somewhere around in April, a few months before the brass pestle incident.
Well,
So
it just has to be relevant to one of them, not to both of them, right? To check the box on relevance.
Sure, Your Honor, if let's say that it was an abuse of discretion to exclude this evidence on grounds of relevance, then the next question is does that evidentiary error in and of itself rise to the level of constitutional error? And the answer is no. The Colorado Supreme Court case of Krutzinger tells us that you have to ask whether the defendant was denied virtually his only means of effectively testing the prosecution's case. And the defendant here had that opportunity.
What was that opportunity?
He cross-examined the children on thoroughly regarding their inconsistent statements, and granted, there were a number of inconsistent statements. He cross-examined the pediatric physician, he cross-examined the law enforcement personnel, their lack of investigation. For example, there was a red substance that was found in the bathroom, on the bathroom walls, on the son's head wrap that he was wearing, but they didn't actually test that substance to confirm that it was, in fact, blood, and to confirm, in fact, that it was the son's blood. But the police officer testified that in his experience investigating crime scenes that he believed it to be blood. So this is not a case where he didn't have the opportunity to poke holes, to put the prosecution's case to adversarial testing. And that is the test here for constitutional error. This is just like the case in Krutzinger, where the Colorado Supreme Court found that there was no constitutional violation, where there was an exclusion of a defense witness because the defendant there, as here, thoroughly cross-examined the victim witness regarding many inconsistent statements that she'd made regarding the assault that had happened to her. So
What about but I guess I want to distinguish the inconsistencies as from the motive to fabricate. And those two kind of go hand in glove. And the closing argument belies as much. I mean, because the prosecution almost sort of concedes, yes, there are inconsistencies, that doesn't mean it's made up. And by the way, there's no evidence whatsoever of a motive. And so the absence of an opportunity to give the jury an explanation as to why the children might do this seems to be completely, that the defense was foreclosed from presenting that critical piece of their theory of the defense. I mean, where was the opportunity to present that? Why wasn't that fully foreclosed?
Your Honor, I think that they could have cross-examined the children, perhaps not specifically as to this specific allegation, but they could have cross-examined, asking them questions that could have supported, part of their theory, which is, you don't want to live with your father anymore. You want to live with your uncle more. You like your uncle more. Anything to that effect that would support this idea that they were making this up because they didn't want to live with their father because he was a strict disciplinarian. And that testimony did come out. The children were questioned about that the defendant restricted their time playing outside, restricted their time with friends, and that they were able to do that more with the uncle. But with respect to the uncle, I mean, the children's testimony was very limited. It was simply that he took them to the forensic interview and that they lived with him up until the time of the trial. So certainly I think that the defendant could have explored that relationship more with the children.
I thought that was shut down a little bit as well, that the ability to explore that was also limited by the court. I mean, one of the other witnesses that they wanted to call was the uncle, and there was a colloquy there. I mean, that's not being appealed to us, but that that line of inquiry and exploring that relationship, it's my understanding the court imposed some limits on.
It was my understanding that the court did not allow the uncle to testify.
Thank you.
He was under subpoena by the defense, and I believe currently had some municipal cases at the time involving his care of the children. So I'm not sure, Your Honor,
Okay.
exactly why he ended up not being called.
But the court made it pretty clear to everybody that we're not going to allow that sideshow about the children's care, what the children's care looked like in the uncle's care, to really be a focus of the trial. I think the judge made that pretty clear that was out of bounds.
Yes, and I think that's right, Your Honor. But again, I don't think that limits what the children could have been asked about in other instances. I mean, there was no questioning whatsoever to the effect of, have you been influenced by someone to come forward? Or
In the case law that talks about the constitutional deprivation, my read of those cases has been that they focus on the cross-examination that was actually conducted and say that was an adequate opportunity to test, as opposed to focusing on the examination that could have been conducted but wasn't. I mean, here, and I just want to know where would you point me for support of the notion that the foregone opportunity to do it through another witness is a substitute, as opposed to looking at the actual testing of the prosecution's case that the defense did when assessing a constitutional deprivation. Am I making sense on that question?
I think you are making sense, and I looked at Golub, I looked at Krutzinger, I looked at Melendez, and you're right. The facts here are not similar. So in Golub, you had an expert witness that was prevented from testifying. In Krutzinger, it was a therapist who'd been prevented from testifying. So I don't think that those cases are necessarily applicable, but I think the import of those cases is that you have to look at the evidence that's been presented at trial and whether this witness is a crucial, critical witness to the defense. And given the very vague offer of proof and absolutely no indication to the court that this was a critical witness, I don't think that the constitutional claim was even preserved, that the court was on notice that a constitutional right was implicated. So if the court doesn't have any further questions, we'd ask that the judgment of conviction be affirmed. Thank you.
Thank you, counsel. Mr. Huff.
I want to spend my time correcting some of the things that the Attorney General said. She said there was nothing in the record that the jury heard linking the uncle to the children, but of course that's not true, and I think it came out a little bit later. There was testimony that they were currently living with the uncle, that he had taken them to some appointments, and they were with him at the time of the trial. The problem is the jury didn't get the connection piece. These kids have a motive to get away from their dad. We can't tell you what that is because the court won't let us. And they end up with their uncle. Wouldn't it have fit perfectly that they got the complete picture, or at least were allowed to debate the complete picture back in chambers or back in the deliberation room? They have a motive to move from their father. The motive is that their uncle told them, I would be a better caregiver, go against your father, he doesn't love you. And lo and behold, the children now live with him. He takes them places. They have what they wanted. Their goal was accomplished. Their motive worked out. Wouldn't have that been fair for the jury to be able to assess that? Secondly, I want to get to Krutzinger, because Krutzinger actually helps in this case. It says, if the exclusion deprived the defendant of a meaningful opportunity to present a complete defense, it's subject to constitutional harmless error. I would argue the court deprived us of completing of having a complete defense. We were allowed to show the inconsistencies. We poked holes in their statements, but the jury was not ever told what the motive was. The court did not allow us to bring to the jury what the motive was, and the prosecution exploited that repeatedly in closing. No motive. That's it. Thank you.
Very good. Thank you, Mr. Huff, and thank you to counsel for your excellent arguments as well as your briefing in this case. This case will stand submitted, and a written order will issue in due course. That completes our 9 a.m. docket, but not our morning. So we're going to take a brief break while we reconstitute the panel, and we'll be back for the 10 a.m. case if counsel for that case wants to please take their seats. You may be seated. Good morning. We are here for our final case on Division 1's docket, People in the Interest of KPC 16CA2239. I know that counsel for both sides are experienced litigators in this court. Do either of you have any questions about our procedures before we begin? All right. With that said, the one reminder that I will give is that it's live streaming, and the arguments will be archived on our website. And this is a juvenile case, so please do not make any references to any of the individuals by name, either by initials or by role. With that said, we'll go ahead and begin with the defense.
May it please the court, my name is Mark Evans, number 40156. I'm a public defender here today representing KPC, and I'll aim to reserve approximately 5 minutes for rebuttal. I'd like to start today by talking for a minute about credibility. You don't get a second chance to make a first impression. It's a cliche because we hear it all the time, but we hear it all the time because it's so important and so true. Once we form an initial judgment about someone, that judgment has tremendous inertia in our hearts and our minds. And that truth about human behavior applies equally to judges. What I hear time and again from judges in CLEs and books on legal writing is that my credibility is my most important asset because once I lose it, it's nearly impossible to regain. Like any other human, judges' initial impressions of someone's credibility have sticking power and influence how they react to that person the next time they meet.
So, counsel, are you saying that anytime there's a pretrial motions in which some evidence is suppressed, that the defendant is entitled to a jury trial in a juvenile case?
No, Your Honor, I'm not. So this type of pretrial consideration of evidence is never a factor in adult cases because a jury is always available. Many juvenile cases go to trial without this sort of pretrial evaluation occurring.
The ones that go to trial usually have some motions practice to them, has been my experience.
Correct, Your Honor. And there's plenty of authority out there for the idea that judges can put out of their mind things that they shouldn't have heard in the first place.
Right.
As in a pretrial, determination of whether certain evidence is going to come in. There is no authority that I'm aware of for the proposition that a judge can make an express finding on the reliability and credibility of evidence and then somehow put that out of mind. And what we see to the contrary is in cases like Estep, the court said that it didn't intend for its comment on credibility to be taken seriously. The court in CY from the supplemental authority said it didn't even remember the prior proceeding at issue. In both of those cases, the judges nevertheless could not serve as the fact finder in the ultimate hearing. And the court in MM expressly said that it was not going to rely on certain evidence, but this court found that under the circumstances of the case, it simply couldn't do so. So I think all of those cases, Elliott and Tepley as well, really stand for just the obvious proposition that judges are human too. And when you've made an express finding that something is credible, you can't just forget that.
But you're always going to, a judge who hears pretrial motions is always going to make some credibility findings, even if it's about the officer who testified at the suppression hearing. I found the testimony to be reliable and credible. Is it then game over as far as the ability of that judge then to sit as the fact finder if that witness is going to testify at trial?
I don't think so, Your Honor. I mean, to be clear, my position here is that if the trial court has made a pretrial determination that the sole evidence of guilt is credible, then that is a situation where in every case you would require, the Constitution would require a different fact finder for trial. Now that said, I think there could certainly be situations where the trial court's pretrial determination of evidentiary issues is more tangential to that issue of guilt or innocence, where the right to a fair and neutral fact finder wouldn't be implicated. And
so is this a constitutional claim?
Absolutely, Your Honor. And I want to make sure that it's clear that there are two separate arguments here about the jury trial issue. The first is that when you do that balancing of interest prescribed by AC, all of the factors weighed in favor of having a jury and nothing weighed in favor of a court trial. But the second argument is that regardless of what AC says and regardless of what the statute says, my client had a constitutional right to a trial by a fair and neutral fact finder. And when the fact finder has already found the dispositive fact before trial begins, that fact finder is not neutral and there can be no fair trial.
Was the constitutional issue raised at the trial court?
Yes, it was, Your Honor.
Where at?
Can I step to my table for a second here, Your Honor?
Sure, or you can address that on rebuttal if you want.
Okay, but in the motion that we filed requesting a discretionary jury trial, we indicated that the court's pretrial credibility rulings would impact its fairness and impartiality. And then when the motion was argued on August 18th, 2016, at pages 2 and 3, we reiterated that same argument. So.
Mr. Evans, if I may. I understand your general statement about first impressions and no second chances. And I think that that's probably a decent rule of thumb when you're talking about hiring someone, even if you're talking about a juror listening to someone in a case. But judges, and of course I'm talking about my colleagues here, I mean, we're trained to look at things a little bit differently. And the context of the first finding, I would submit to you, doesn't eliminate the prospect that in a trial, something else that might come out, or simply things might be significantly different enough that the judge would say, I don't believe this anymore. And I would submit to you that that happens all the time. Now, you may suggest that that's simply a legal fiction and that we judges have created that in order to cover our own backsides. Fair enough. I certainly wasn't in the room when that idea was originally proposed. But I would suggest to you that there is a difference here in the fact that judges are trained to look at things differently. And because of that, a judge, I would submit to you, can set aside an initial finding, a pretrial finding, and look at that same issue, that same witness, that same piece of evidence, dispassionately and fairly come trial time.
Well, Your Honor, I'm quoting the Colorado Supreme Court here in a step. Prejudgments regarding the quality of evidence to be heard are not consistent with the duty of the trial court to reach an unbiased decision after weighing all the evidence. And what was at issue in a step was just the trial court's offhand remark when scheduling a post-conviction hearing to the effect of, I hope this witness is more credible than your last.
Pardon me for interrupting, and I'm sorry, and I'll give you plenty of time to answer. But in this case, the finding that you're concerned with was a part of the trial court's obligation in the first instance. It wasn't making offhand remarks, it was doing its job.
That's correct, Your Honor, but I think that that's what makes this an even weightier obligation. This wasn't an offhand comment. It was the court's job to make that credibility finding. And when the court serves that gatekeeping role, when what it's, the evidence at trial really wasn't much different from the evidence at the motions hearing. When the court has already performed that role for the only evidence of guilt, that's where, when you look at the factors prescribed by AC, the specific facts of the case indicate that you need a jury in this case.
Or in the alternative, a different judge? Would that have also cured it?
I think there would be some logistical difficulties with that. But potentially, yes. I think that the point of the argument is that you need a different fact finder, and there are probably other ways to do that. But having the same person who already found the witness credible listen to the same witness in the same videotape and provide testimony about the same thing, that's not a neutral fact finder. The fact finder has already made the critical decision in the case. And again, I think that there's a real critical distinction here between situations where a judge hears or evaluates something and says, makes a decision, this isn't relevant, this shouldn't come in. The judge is deciding for him or herself that information shouldn't influence the decision. When the judge makes a finding on credibility, especially when it's the only evidence at trial, all I know is that I, as a person, could not put that out of my mind. And I think that Estep and Elliott and CY and all those cases support that that's not something that anyone can do.
I'm worried a little bit about a slippery slope that this opens, as you might imagine. I mean, what about a circumstance under which there's a 404B motion, and so there's other bad acts that are offered to come in, and the court ends up denying those, but then ends up sitting as the fact finder? Would that require either recusal or jury trial?
Your Honor, I think that as AC prescribes, this is a case-by-case specific determination. And again, I'm not saying that any pretrial ruling is going to require a jury trial. I think that the line that this case presents is just that when the court has found the only evidence or the only critical evidence of guilt to be reliable, that's where the right to a fair and neutral fact finder is violated.
And you're asking for a per se rule under those circumstances?
Yes, Your Honor, I am. I mean, if the court has said the only evidence of guilt is credible, yes.
And how does that square with the case law that Judge Bernard identified, where we presume that a judge is different and has some sort of superpower to put these sort of things out of their mind?
Your Honor, it doesn't square with it because they're talking about different subject matter. Those cases are talking about evidence that was irrelevant or shouldn't have come in. I mean, Liggett is the perfect example. The cases that I'm presenting to the court, Estep, CY, Elliott, Tepley, those are cases where the judge has made a decision about the credibility of evidence or prejudged evidence. That's what's applicable to this case, and that's what indicates that we needed a different fact finder. If this court has no further questions, I'll reserve my remaining time for rebuttal.
Thank you.
Good morning, Your Honors. My name is Joseph Michaels, attorney registration number 40403. I'm here today on behalf of the people of the state of Colorado. I'm going to restrict my comments to the first issue, but I'm happy to discuss anything about the second issue or any issues that this court finds pertinent beyond my discussion points. And I'll start by very simply saying the statute is very clear about what is and what is not required, and our Supreme Court has been very clear about what is and what is not required to assess. There is no constitutional right to a jury trial in juvenile cases, and the legislature has imparted a statutory one in certain circumstances. That framework is what governs this claim, not a super constitutional framework or a credibility-specific framework or a constitutional issue about whether a court can predetermine credibility. And I will talk about credibility specifically, but I want to talk first more broadly about the discretionary issue and how the court here specifically exercised its discretion. And it did so by identifying three different things, at least, in the order that, in its order denying the discretionary jury trial. First, it reflected specifically not only on the state of the law generally, and recognized a division of this court's decision in ABB, which presented almost identical claims in terms of the underlying offense, but it also reflected on the facts of this case, as saying there's nothing in here that specifically is more or less difficult or more or less onerous in terms of necessitating a jury trial. Second, it recognized the statutory preference for a trial to the court in circumstances like this.
Where does that statutory preference come from? That piece confused me. I mean, there's a statutory requirement, there's a statutory prohibition, and then there's a middle ground that's discretionary. But where does it indicate that there is a preference for a court trial in the discretionary category?
The preference comes from the overarching purpose of the Children's Code in that trials be informal and to the court and much more speedy and less onerous as an entire rule. So it's extrapolating, yes, there's nothing specifically identified in 19.2.107.
So you don't think the court got that wrong when the court said that there's this preference?
No, I don't think the court got that wrong.
What if I disagree with you that there is not a statutory preference one way or the other, and that statement of the trial court doesn't find support either in the statute or the case law? What does that do to the trial court's determination and to our review of it?
Respectfully, it doesn't do anything. And the reason I say that, not to be flip, Your Honor, is first of all, our Supreme Court has expressed this statutory or this preference for informality. That's the AC case, and multiple divisions of this court have played lip service to that. And two, perhaps even more importantly, it shows that the court is still exercising its discretion in terms of, I believe the preference is this, even if that is wrong as a matter of law, it's still suggesting that the court is reflecting on the statute, on the purpose of the statute, on the purpose of the criminal code, or the juvenile code as a greater rule.
Is it possible for a court to abuse its discretion in denying a jury trial to a juvenile under circumstances where it's discretionary?
Yes, I think it is, but this is not that case.
Give me an example of how a court could abuse its discretion.
I think if, for example, this is making me think a little quickly on my feet, but I think there would have to be.
That's the fun of oral argument.
It's the fun of appearing in front of any of your divisions. I think if the court was familiar with a juvenile, specifically as a prior prosecutor or a prior defense counsel who immediately took the bench and had.
That would require recusal, wouldn't it? I mean, the court couldn't preside over that case. That's a different. They're entitled to a different judge. They're not entitled to a jury by virtue of that.
That's probably true, but there would have to be a motion to recuse, and I'm glad you brought that up because that is an issue that occurs here. There's a discussion about how this court was incompetent to judge the credibility, but there was no motion for this court to recuse, and that goes to the question that you raised to Mr. Evans about does this raise a specter of every court having to recuse when it hears pretrial motions? Absent a motion to recuse like that, then there's no way that this court should have known how to do that or known that it should have done that, especially given the state of the law at the time of trial and the state of the statutory requirements for the jury trial. To answer your question, I don't have a good hypothetical, quite honestly. Yes, it would be a very special snowflake situation. And the reason I say that is because the legislature has already imparted a great number of instances where jury trial is required. So the legislature has essentially exercised...
Two, really, isn't it?
Well, it's a number of, two, but then they have multiple permutations down the line. So that's what I mean by great number. You're right, the crime of violence or prior offenders. But those crime of violence acts have a great number of crimes that they envelop on the whole.
And I wasn't asking this question just to torture you or to see you think on your feet. I mean, we were trying to bounce this around in chambers that this is a rare circumstance in which, I mean, yes, we call it abuse of discretion, but can the court pretty much just deny it for any reason and it's virtually unreviewable under the statute? If a court can it just say, I don't want to go through the pain of picking a jury, and so I don't have to give you a jury trial, so I'm not.
I think when we start to glean, to look at sort of a synthesis of the overall arching cases, you get ideas of what is important for a jury trial case. So ABB and even TB talk about a few things that sort of trigger it, and it's complexity of case. The more complex the case, the more witnesses, the more time, the more impact on the community safety standards, the more impact on the victims. Perhaps you start to see this idea of necessitating a jury trial. And I'm glad that you say, well, what is an abuse of discretion? Because a previous division of this court in People in the Interest of TB, which is cited in either the opening or the reply brief, or maybe both, but it's 2016 COA 151M, and Your Honor, Judge Bernard, you especially concurred in that. they explicitly recognize that that court didn't even make any findings about the discretionary jury trial, and the division upheld it. And the reason is the legislature has essentially exercised a court's discretion as a threshold for what amounts to a discretionary, or in this case, a mandatory need for a jury trial. And anything beyond that is a very, very specific and narrow set of circumstances, not one that is as simple as here and that almost directly parallels the ABB case in terms of the offense at issue and the quantum of evidence and the type of evidence that's coming in, specifically witness testimony about what happened, what didn't happen. To answer your question and maybe squirm a little bit more, I don't know.
Okay.
But
That's fair enough.
But I think it's a smell test. You look at the facts of the case, and if there's an overwhelming idea of this is too much for a court to take on as its role as both fact finder and legal threshold, or it just would reflect on the integrity of the jury, the judicial system as a whole, I think the court is entitled to make that determination on its own. But a court here, which is making the opposite determination, saying, I've looked at this case, I've looked at the facts of this case, I've looked at the law around the idea of a discretionary jury trial, and this case is very similar to cases that divisions of this court and the Supreme Court have said a jury trial is not required, and the statute says a jury trial is not required. It's very hard to then come back and say, well, that court clearly abused its discretion when all the case law is consistent in saying that a jury trial is not required in this situation. Which brings me, I think, to the point of credibility that opposing counsel is really pushing, particularly in the reply brief. My recollection of the record is that they did not raise a constitutional issue about credibility. But even if we do, opposing counsel's statement about you only have one shot to make a great first impression is true, but Your Honor, Judge Bernard, I think you're right that judges look at things a little bit differently. And I would posit that the credibility to offer testimony, which is what it was at issue at the pretrial hearing, is not the same thing as the credibility of that testimony itself. And that's what's at issue at trial, not the credibility of the witness offering the testimony. Otherwise, we run into problems with suppression, with 404B, with child hearsay every time, with closed curtains, with CCTV. All these things that we trust trial courts to make and always have. There is not a single case here in Colorado that says it becomes a constitutional issue when a credibility to testify, not of the substance of the testimony, but the credibility to testify is at issue. And what that would do, Your Honor, Judge Welling, I think you were the one to point out, that said it would require a bright line rule where a court would have to recuse itself. I would argue that the better response would be there would have to actually be a motion to recuse. But it also suggests the problem here, which is this court was never put on notice that it had to recuse. It was never asked to recuse. And under questioning, opposing counsel even said that had the judge recused, then there wouldn't have been an abuse of discretion in violating or in the right to a jury trial because the jury trial wouldn't have been necessary. So then we come back to this idea of, can a court assess credibility? And I think case law, decades and decades of it, are clear that yes, a court can assess credibility and then put it aside in order to assess the ultimate determination of fact. And I would suggest that a step is a very, very different circumstance than what we have here. What we have here is we have, at a motions hearing, a court exercising its independent function of whether to allow evidence in, not judging the evidence based on the substance of the evidence, but allowing it to come in. And in a step, we had a judge who made an offhand, sure, but a comment that clearly reflected, and perhaps the offhand nature makes it even more of an honest reaction, but the offhand comment suggested that this court had already judged the witness and the issue against the defendant. There's no suggestion of that here. There's a court that just said, I can hear this evidence because you've established the threshold to bring it in. It's about admission of evidence versus evaluation of the evidence. If the court has no more questions about the credibility, I do want to talk very quickly about this idea of collateral consequences. Hearing no more questions, I will quickly turn to that. The reply brief raised a new and very troubling argument, I thought, that was not raised in the opening brief. And that's this idea that collateral consequences are somehow punitive and have been found punitive under the federal district court's case of Miller versus Rankin. And that issue was simply just not presented below. It was not presented in the opening brief. And for a lot of reasons that I won't go into, that position has been rejected multiple times by our Supreme Court and by divisions of this court. And I would just say it's not worth this court going down that rabbit hole because it wasn't presented below, it wasn't presented in the opening brief, and it's certainly not properly presented on appeal.
And when you say it's been presented multiple times, do you mean the issue of whether or not the registration requirement is a penalty?
Yes.
Well, but this is framed a little bit different, that what the court is supposed to look at is the seriousness of the consequences as opposed to the penalty. I mean, that's my understanding of the argument as to why that case law doesn't dispose of the issue, because even if it's not considered punitive, it's still a serious consequence, which is, I mean, it's hard to deny that it's a serious consequence and therefore should be considered in that light. That's my understanding of the argument.
May I respond?
Yeah.
There are 2 points to that. One, it is first presented as it is a serious consequence, and that position has been explicitly rejected over and over and over again. And in fact, even in the annotated section to 19.2.107, there's a little blurb from AC that talks about how the purpose of the juvenile discretionary jury trial is not about the collateral consequences or the unique impact, but rather about the fact that there is the nature of the jury trial right, the nature of juvenile proceedings does not guarantee you that right. And there have been a number of cases, JO, JT, IS, all cited in the answer brief that just said it's the collateral consequence, the heavy impact of registration is not sufficient to grant a jury trial. So that's very clear. There's no dissension among the ranks on that. The other aspect is there is a change in argument in the reply brief where it starts to say collateral consequences such as sex offense registration should be treated differently than crime of violences, which is frankly a plea to the legislature to change it. And in light of different case law from different jurisdictions, it should be considered punishment. And that argument was never raised, and that's the one that I'm objecting to this court addressing at any junction now. If this court has no further questions, I would urge this court to find that the trial court in this instance exercised its discretion appropriately, clearly, and as a gatekeeping function was able to judge the credibility of witnesses to give testimony, but not judge the ultimate issue of that credibility or their testimony until trial. Thank you, Your Honors.
You have approximately 4 minutes remaining, Mr. Evans.
Thank you, Your Honor. Judge Welling, you asked what impact it has if this court disagrees that there's a preference for jury trials. As this court alluded, there is no preference for jury trials, but where it puts this court is that that indicates that almost the sole basis for the trial court doing what it did was based on a misunderstanding of the law. That's an abuse of discretion and puts this court in a position where it's then asking whether it can otherwise affirm based on the record. And as laid out in the reply brief, when you look at those scales established by AC, every single thing weighed in factor of having a jury in this case.
But what if we disagree with you on that piece of it? That there are factors. This wasn't a particularly complex case, limited number of witnesses, particularly young victim. I mean, there's the scales, I think, are open to a different view than everything falling on one side. What if we find they're more balanced or tip in favor of that finding, but we disagree with the threshold determination of the presumption?
Well, Your Honor, again, I think that if this court agrees that having the same fact finder preside at trial deprived my client of his constitutional right to a fair and impartial fact finder, then there is no balancing that out. That piece of it is heavy enough to permanently set the scales going that direction. I think that the relevance of Billiard in this case is really just getting around this idea that because we've said in the past all these requirements are imputative, then they just don't go on the scale at all. No, they do. I mean, as you indicated, that is, if nothing else, a consideration that should weigh very heavily in favor of having a jury.
But you don't contend that that creates the same sort of per se circumstance, that if there's a potential for a registration requirement, that the court then must grant a jury trial? I want to make sure I understand the argument.
Correct, Your Honor. I'm not saying that's going to be true in every case. I do think it is a very weighty factor, but are there situations where it could be outweighed by something else? Sure.
Okay.
The fair and impartial fact finder can't.
Because to the extent that it's a contention that it should be required under those circumstances, that's an issue for across the street as to whether or not they want to add a third category of mandatory jury trials, right?
I believe that's correct. It's just a factor in how the court exercises its discretion. Regarding how to tell whether there's an abuse of discretion that happened here, the Attorney General characterized it as a smell test. I think it's a little more nuanced than that, but imagine being my client. Imagine being charged with one of the most serious offenses known to Colorado law, one that carries with it this lifetime of debilitating consequences, and walking into a trial where you know that the fact finder has already determined that the only evidence against you is credible. That stinks. In that situation, when the court has already made a pretrial determination on the record that the critical evidence is credible, a different fact finder is constitutionally.
Wasn't the court just exercising its gatekeeping function to say it's sufficiently credible to be admissible?
But in this, at least in this limited context of evaluating things under the child hearsay statute, I mean, the gatekeeping function is a finding that the evidence is credible. And when you look at the factors that the court's supposed to consider.
Or is reliable? Is it reliable, or does that matter?
I see I have 9 seconds left.
Sorry.
Can I go ahead and answer your question, Your Honor? Okay. So when you look at the factors that the court has to evaluate during that child hearsay hearing, things like whether the statement was spontaneous, whether it was in response to leading questions, whether there's evidence of a motive for lying, I mean, that's not going toward the fidelity of the recording equipment. It's going toward whether what was being said was actually true. That's what the court was required to do. And once the court's done that, people just can't let go of that. I respectfully ask this court to reverse KPC's adjudication.
Thank you, counsel, for your excellent arguments as well as your briefing in this case. This case will stand submitted, and a written opinion will issue in due course. This concludes both our argument in this case as well as today's proceedings for Division 1, and we will be in recess if the bailiff is so announced.